Good morning, this is your Kelso Report for Thursday, December 20th. I'm your host, Clark Kelso. Our first case arises under the immigration laws and involves a collateral attack on a prior removal order. Next, we have a tax case involving net operating losses and the alternate minimum tax. We then turn to a civil procedure holding involving the consequences of having a suspended corporate license. And we close with a case involving the right to be informed of the right to counsel at a probation revocation hearing. Our system of judicial and administrative justice has the concept of due process at its core. But sometimes the end result in a proceeding would be the same even if procedural due process rights had been fully observed. This, of course, raises the question of whether a person who has suffered a procedural due process violation or default must establish prejudice to receive a meaningful remedy for the violation. That essentially was the issue before the Ninth Circuit in United States v. Bustos Ochoa, an immigration case where an alien had been deported and then re-entered the United States illegally. He was arrested, and in a criminal trial where he was charged with illegal re-entry after deportation, the alien sought to collaterally attack the prior removal order by claiming that the immigration judge had failed properly to advise him about a procedural avenue for relief from deportation. But the Ninth Circuit held that to successfully mount such a collateral attack, the alien had to demonstrate prejudice. And in this case, the alien concededly was statutorily ineligible for the alternative relief. Since the alien could not establish prejudice on the merits, the Ninth Circuit held the alien could not collaterally attack the prior removal order, so his conviction for illegal re-entry after removal was affirmed. Next, a tax case. The alternative minimum tax is one of the most ugly ducklings of the modern tax code. In order to provide taxpayers with some relief from the AMT, between 2002 and 2009, Section 56 of the Internal Revenue Code provided tax relief by permitting taxpayers subject to the AMT to offset up to 100% of their taxable income with net operating losses. But not all NOLs were covered. To qualify for this relief, an NOL had to be carryovers to the 2001 or 2002 tax years, or carried back from the 2001 or 2002 years to a prior tax year. In Metro 1 versus the Commissioner, the taxpayer sought to benefit from the exception by carrying its NOL back from the 2003 and 4 tax years to the 2002 tax year. Well, the Ninth Circuit rejected this, citing the plain meaning of the term carryovers, which prevents taxpayers from using NOLs that are carried back to 2001 or to 2002 from a later tax year. Now, does any of this make any policy sense? Well, I don't think so, not a bit. But our tax laws have become so twisted by special interest pleadings and exceptions that no one should be looking for a great deal of rationality in the tax code. After all, as we could plainly see in the negotiations on the so-called fiscal cliff, it all is just a matter of drawing arbitrary lines and playing games with the numbers to produce the right amount of revenue. Now we turn to a civil procedure case under California state law. A corporation that fails to file a tax return or fails to pay its taxes, penalties, or interest can have its corporate license suspended by the Franchise Tax Board. The suspension of the corporate license means, among other things, that the corporation loses its capacity to sue. That is what happened to the plaintiff in V&P Trading versus United Charter, a premises liability case. The defendant apparently did not notice the suspension until about 9 months into the case, when a discovery dispute arose, and the plaintiff made a motion to compel answers to a set of interrogatories. The defendant then raised the issue of the suspended license as a defense to the motion to compel and sought sanctions. Although the plaintiff then revived its corporate license by filing with the Franchise Tax Board, by that time the statute of limitations had run, and the Superior Court granted the defendant's motion for summary judgment. On appeal, the 3rd District affirmed the summary judgment. Although the plaintiff's capacity to sue had been properly revived, the revival did not have the effect of tolling the limitations period nunc pro tunc. So, even though the suit was timely filed, the limitations period had run by the time the license was revived, and the 3rd District held the suit was therefore time-barred. On the sanctions issue, by contrast, the court held that the defendant had waived the suspension of license and lack of capacity to sue defense by failing to raise it at the earliest time it could have raised it, which would have been the defendant's answer to the complaint. As the court explained, the license suspension and lack of capacity to sue defense is a disfavored defense in the law, so the failure to raise it constitutes a waiver. Nevertheless, the lesson of this case is clear. Make sure you file your corporate taxes, because the consequences of failing to file and of losing your corporate license can go way beyond a mere tax penalty. Finally, a right to counsel case. The federal constitutional right to counsel applies at all critical stages of a criminal proceeding in which the substantial rights of a defendant are at stake. A sentencing hearing is one such stage, and a defendant has a constitutional right to counsel at sentencing, even when it is accomplished as part of a subsequent probation revocation proceeding. The constitutional right to counsel encompasses the right to be informed of the right and of the dangers and disadvantages of self-representation. In People v. Bauer, the defendant had represented himself in his criminal trial after being properly notified of his right to counsel. He was sentenced to a term of probation with conditions. Months later, he violated his probation and was brought back to court for a probation revocation hearing. Well, at this hearing, he was not informed of his right to counsel. The 4th District held that this failure was a fatal error in the proceedings, and that his prior waiver of counsel did not carry over into the probation revocation hearing. So the court reversed the revocation of probation and remanded so that the defendant could invoke his right to counsel, and the Superior Court could then hold a proper probation revocation proceeding. And that's it for today's Kelso Report. Have a great day in the law.